I have seen people lie under oath. I have seen defendants walk into my courtroom wearing fake confidence like armor. But the day Karen Whitfield looked me in the eye and claimed my courtroom was rigged, I knew the real case had not even started yet. Before we go any further, make sure you have subscribed to this channel for more powerful courtroom stories like this one. And if you haven't subscribed yet, do it now. Also, comment below and tell us where you are watching this video from. Now, let me take you back to where this case truly began. Her name was Karen Whitfield. And from the moment she stepped through those courtroom doors, she carried herself like a woman who had already written the ending in her own mind. She was not nervous. That was the first thing I noticed. Most people who enter a courtroom, even the loud ones, even the angry ones, carry some kind of tension in their body. Their eyes move too quickly. Their fingers tap against the table. Their shoulders stay tight because deep down they understand something important. A courtroom is not a stage. It is not a social media comment section. It is not a place where volume replaces truth. But Karen did not seem to understand that. She walked in wearing a bright red blazer, oversized sunglasses pushed up into her blonde hair, and a thin smile that never reached her eyes. Behind her, a small group of spectators whispered as she made her way to the defendant's table. She didn't look at them. She didn't look at the plaintiff. She looked directly at me, not with fear, not with respect, with challenge. Years on the bench teach you to recognize certain looks. Some people look at a judge hoping to be understood. Some look hoping to be believed. Some look hoping for mercy. Karen looked at me like I was an obstacle, and that told me more than her opening statement ever could. The case appeared simple on paper. A retired school librarian named Margaret Collins was suing Karen for property damage, harassment, and unpaid repair costs after a neighborhood dispute turned ugly. Margaret was 71 years old, soft-spoken, and the kind of woman who clutched her folder of evidence with both hands as if it were the only thing keeping her steady. Across from her sat Karen, arms crossed, chin raised, smiling like the entire case was beneath her. I remember looking down at the complaint, a damaged fence, security camera wires, cut threatening messages, a broken porch window, and one accusation that immediately caught my attention. Margaret claimed Karen had spent 6 months trying to force her out of the neighborhood. At first, that sounded extreme. Then I looked at Margaret's hands. They were trembling, not dramatically, not in a way meant to gain sympathy, just enough for me to notice. That is something people at home do not always understand. In a courtroom, truth often speaks before the mouth does. It shows itself in small movements, a swallowed breath, a lowered gaze, a hand gripping paper too tightly. Margaret was afraid, Karen was entertained. That contrast disturbed me. When I asked Karen if she understood the claim against her, she leaned back and gave a little laugh. "Your Honor, this whole thing is ridiculous," she said. "She's obsessed with me. She's been trying to make me look bad for months." I watched Margaret flinch, not at the words, at Karen's confidence. There is a kind of confidence that comes from innocence. And there is another kind that comes from believing you can control the room. Karen had the second kind. I asked Margaret to explain what happened. Her voice was quiet at first. She told the court she had lived in that small suburban neighborhood for 38 years. Her husband had died 5 years earlier. Her children lived out of state. The house, she said, was the last piece of her old life she still had. Then Karen moved in next door. At first, the complaints were small. Karen said Margaret's flower pots were too close to the property line. Then she complained about leaves falling near her driveway. Then she accused Margaret of ruining the value of the street because her house looked old. As Margaret spoke, Karen rolled her eyes. I saw it. The bailiff saw it. Even the clerk saw it. But Margaret continued. She said the arguments became more personal. Karen called her lonely, called her bitter, told other neighbors that Margaret was unstable. Then came the damage. A fence panel cracked, a porch light smashed, a handwritten note left in Margaret's mailbox that said, "Move before things get worse." The courtroom went still when Margaret read those words aloud. Karen shook her head and muttered, "Fake." I looked at her. "Ms. Whitfield," I said, "you will have your opportunity to speak. Until then, you will not interrupt." She smiled again, but this time I saw irritation beneath it. That was the first crack. And in my experience, when controlling people lose even a little control, they begin to reveal themselves. Margaret submitted printed photographs, repair bills, and screenshots of messages she claimed Karen had sent from a neighborhood app. Karen objected immediately, saying the screenshots were edited, the photos were staged, and the bills were exaggerated. Then she said the words that changed the entire temperature of the courtroom. "This court already decided I'm guilty before I walked in." I paused. The room went silent. Karen sat forward, her voice sharper now. "This is rigged," she said. "Everyone here can see it. You're siding with her because she's old and pathetic." I remember the sound that followed, not a gasp exactly, more like the whole courtroom inhaled at once. Margaret lowered her eyes. Her lips pressed together, but she did not speak. I have been insulted before. Any judge who has served long enough has heard worse, but this was not about me. It was about the pattern unfolding in front of us. Karen did not just deny the evidence. She attacked the victim. She attacked the process. She attacked the courtroom itself. That is a strategy I have seen from manipulative people many times. When the facts are dangerous, they try to make the judge the issue. They try to make the victim look emotional. They try to turn accountability into persecution. But what Karen did not know was that Margaret had not brought everything with her. Not yet. I leaned forward and asked Karen one simple question. "Ms. Whitfield, are you saying every piece of evidence presented today is fake?" She didn't hesitate. "Yes," she said. "All of it." That answer mattered, not because it was loud, because it was absolute. In court, absolute denial can be a dangerous thing. Once a person says everything is fake, they leave themselves no room to explain the one thing that is real. And I noticed something then. Margaret's attorney, a calm woman named Rachel Morgan, did not look surprised. She did not object. She did not argue. She simply looked down at a sealed envelope sitting on her table. And for the first time that morning, Karen's smile faded, just slightly. But I saw it. Rachel Morgan rose from her chair and said, "Your Honor, before we continue, we have one additional item we would like to introduce." Karen turned her head quickly, too quickly. That was when I knew whatever was inside that envelope, Karen already feared it. And within seconds, the entire courtroom would understand why. Rachel Morgan held that sealed envelope with both hands, and I remember thinking how calm she looked. That calmness mattered. In a courtroom, people who are bluffing usually try too hard. They speak louder. They rush. They perform certainty because they do not actually possess it. Rachel did none of that. She simply stood there waiting for permission. Karen, on the other hand, had changed completely. Only moments earlier, she had been leaning back like the courtroom belonged to her. Now her shoulders had tightened. Her eyes kept moving from the envelope to Margaret Collins, then back to Rachel. It was fast, subtle, but I saw it. And believe me, after years on the bench, when someone suddenly becomes interested in evidence they just claimed was fake, you pay attention. I allowed Rachel to continue. She explained that the envelope contained a certified copy of a maintenance report from the neighborhood security company. According to Rachel, Margaret's home camera system had been damaged months earlier. But not all footage had been lost. Karen gave a short laugh. "Convenient," she said. I looked at her. She stopped smiling. Rachel continued. She said the system had stored short motion-triggered clips before the wires were cut. Not full recordings, not enough to show everything, but enough, she believed, to show the beginning of what had happened. Margaret sat very still. I remember her face clearly. She was not excited. She was not satisfied. She looked like a woman who was afraid to hope. That is something I have never forgotten about victims. People imagine they want revenge. Most of the time, they simply want someone in authority to finally believe them. Rachel handed the envelope to the court officer, and as it was brought to me, Karen suddenly spoke again. "I object," she said. "You are not an attorney, Miss Whitfield," I told her. "You may explain your objection clearly, but you will not shout over the court." Her jaw tightened. "That footage is illegal," she said. "She can't record me." I turned the envelope over in my hands. "She can record activity visible from her own property," I said, "especially when the camera is attached to her home and directed toward her own yard." Karen blinked. For the first time, she had no immediate answer, and that silence told me something. Karen had not expected rules. She had expected outrage. There is a difference. Manipulative people often rely on emotional chaos. They expect others to get confused, defensive, embarrassed. But when you answer chaos with law, they begin to lose balance. I reviewed the certification. The dates matched the complaint. The report confirmed damage to the wiring. The file had been extracted by a technician before full system failure. It was admissible enough for review. Rachel asked to play the footage. The courtroom lights dimmed slightly as the screen came on. And suddenly everyone stopped moving. The video was grainy, black and white, silent. The angle showed Margaret's side yard, part of the fence, and the narrow strip between the two houses. At first, nothing happened. Then a figure entered the frame, a woman in a light-colored coat, blonde hair, sunglasses on her head. Karen shifted in her chair. The woman in the footage moved toward the fence and looked around. The clip ended. Only 8 seconds. That was all. Karen immediately laughed again, but the laugh sounded different now. "That proves nothing," she said. "A woman walked near a fence. Congratulations." Rachel nodded. "You're right," she said calmly. "That clip alone does not prove property damage." Then she asked to play the next one. This time, the room felt different before the footage even began. The second clip showed the same side yard at night. The porch light flickered near the edge of the frame. A shadow appeared beside them. The person bent down near the camera cable. The clip froze. Rachel looked at Karen. "Miss Whitfield," she said. "Is that you?" Karen crossed her arms. "No." I watched her face, not her mouth, not her posture. Her eyes. Most people look at the image when denying it. Karen looked at Rachel. That is a small thing, but small things matter. She was not studying the footage because she already knew what was there. She was studying the person presenting it. That told me she was calculating. Rachel zoomed the image. The person's face was not perfectly clear, but the clothing matched. The hair matched. The sunglasses were visible on top of the head. Karen leaned forward suddenly. "That could be anyone," she said. "A lot of women have blonde hair." Margaret whispered, "Not at 2 in the morning outside my house." Karen turned toward her. "You are obsessed with me," she snapped. The bailiff took one step forward. I raised my hand. The room settled again, but barely. I could feel the tension moving through the spectators. Even the jurors, though this was not a jury trial, would have felt it. There is a moment in some cases when people stop watching like an audience and start listening like witnesses. We were getting close to that moment. Rachel then introduced the maintenance invoice. The technician had found the camera wire cut cleanly, not chewed by an animal, not torn by weather. A sharp tool had been used. Karen said nothing. That was another change. She had something to say about every accusation until the evidence became specific. Then Rachel asked Margaret about the note in the mailbox. Margaret opened her folder slowly and pulled out a plastic sleeve. Inside was the handwritten note, "Leave before things get worse." Her hand shook as she held it up. I asked Karen if she recognized it. "No," she said quickly, too quickly. Rachel asked permission to approach with a comparison document. Karen's eyes narrowed. "What comparison document?" she asked. Rachel did not answer her. She handed me a printed copy of a complaint Karen herself had filed with the Homeowners Association 3 months earlier. It was signed by Karen Whitfield in blue ink. At first, I looked only at the signature. Then I looked at the note. Same unusual slant, same sharp downward pressure on the letter M, same habit of making the letter G with a long tail curling backward. I am not a handwriting expert, and I would never pretend to be one. But judges notice patterns, and this one was hard to ignore. Karen saw me comparing the papers. Her face changed again, not fear exactly, anger, because now the courtroom was no longer responding to her performance. It was responding to evidence. She stood up. "See," she said loudly, "this is exactly what I'm talking about. You're all working together. You already made up your mind." I told her to sit down. She did not. For 3 seconds, nobody moved. 3 seconds can feel very long in a courtroom. Then I said her name again, slowly. "Ems Whitfield." "Sit down." She sat, but the look she gave me was cold enough to quiet the room. That was when I understood something important. This was not just about offense. It was not just about a broken camera or a threatening note. Karen needed control. She needed Margaret afraid. She needed the court uncertain. She needed every person in that room to doubt what they were seeing. And when that stopped working, she became dangerous in a different way. Rachel Morgan then reached for a second folder, a darker folder, one I had not noticed before. She looked at me and said, "Your Honor, the plaintiff also requests permission to introduce evidence from another neighbor." Karen's head snapped toward the gallery, and in the back row, an older man slowly stood up. That was the moment Karen's confidence finally cracked. The older man in the back row was named Harold Bennett. He was 68 years old, a retired postal worker, and according to the file, he lived directly across the street from Margaret Collins. He did not look like a man who wanted attention. He rose slowly, one hand gripping the bench in front of him, his face serious but uncomfortable. Karen stared at him like he had betrayed her. That look told me something before he said a single word. People who have nothing to hide usually look confused when a new witness appears. Karen looked offended. There is a difference. I allowed Rachel Morgan to question him. Harold stepped forward and took his place. His voice was low but steady. He explained that he had watched the tension between Karen and Margaret grow for months. At first, he said, he thought it was just another neighborhood argument. People argued over lawns, fences, parking spaces, pets. Small things become large when pride gets involved. But then, according to Harold, Karen began acting differently. She watched Margaret's house. She slowed down when driving past. She took photos from her porch, and one evening Harold heard Karen shouting across the yard that Margaret would regret staying there. Karen shook her head, whispering something under her breath. I told her once again to remain silent, but her face had hardened now. Harold then said something that changed the direction of the case. He told the court Karen had visited him 2 weeks before the hearing. Rachel asked him why. Harold swallowed. "She wanted me to sign a statement," he said. The courtroom became very quiet. I leaned forward. "What kind of statement?" Harold looked at Karen, then back at me. "A statement saying Mrs. Collins had been harassing her, saying she made up stories, saying she was confused." Margaret closed her eyes, not dramatically, just briefly, as if another piece of pain had finally been spoken out loud. Rachel asked, "Did you sign it?" "No," Harold said, "because it wasn't true." Karen slammed her palm on the table. "That is a lie." The sound echoed through the room. I looked at her for a long second. In every courtroom, there is a line. People can be emotional. They can be upset. They can disagree. But when someone tries to intimidate a witness from the defense table, the court has to act quickly. "Miss Whitfield," I said, "one more outburst, and I will hold you in contempt." She leaned back, breathing hard. But even then, she tried to smile. That smile bothered me more than the outburst. Anger is human. Fear is human. Even denial is human. But a smile used as a weapon is something else, Harold continued. He said Karen did not only ask him to sign the statement, she had already typed it. She brought it in a folder. She told him it would be better for everyone. If Margaret learned she could not turn the neighborhood against Karen, Rachel asked if he still had the statement. Harold nodded. Karen went pale, not completely. Not enough for everyone to notice, but I noticed the document was handed to the court. It was printed, neat, carefully worded. It described Margaret as unstable, obsessive, and unreliable. It claimed she had a history of making false accusations against neighbors. Rachel then asked Harold one final question. "Mr. Bennett, did Mrs. Collins ever ask you to lie for her?" "No," he said. "Did Miss Whitfield?" Harold looked down. "Yes." The silence after that answer was heavier than the answer itself. That is one of the strange truths about courtrooms. Sometimes the loudest moment is not when someone screams. It is when the truth lands and no one knows how to move around it. Karen's attorney, a young man named Thomas Reed, looked deeply uncomfortable. He had barely spoken since the footage appeared. I could see him reviewing his notes, trying to decide whether his own client had told him the full story. That is another thing viewers should understand. A lawyer can only defend the case the client gives them. And sometimes during testimony, the lawyer discovers the client has been hiding the most dangerous facts. Thomas stood and tried to redirect the damage. He asked Harold whether he disliked Karen personally. Harold said no. He asked whether Harold had ever argued with Karen over parking. Harold said once, briefly. Thomas tried to suggest Harold was biased. But it did not work, because bias does not create a typed false statement. Bias does not cut camera wires. Bias does not leave a frightened woman alone in her home reading a note that says, "Move before things get worse." Karen watched the questioning with narrowed eyes. She no longer looked amused. She looked cornered. And cornered people often make their worst mistakes. Thomas sat down. Then Karen leaned toward him and whispered sharply. I could not hear the words, but I could read the energy between them. Thomas shook his head once. Karen whispered again harder. He leaned back, refusing. Then she stood. "Your Honor," she said, "I want to speak for myself." Thomas immediately rose. "Your Honor, I would advise against." "I don't care what you advise," Karen snapped. There it was. The mask slipped in full view. For most of the morning, Karen had aimed her contempt at Margaret, at Rachel, at the court. But now even her own attorney became a target the moment he stopped serving her performance. I allowed her to make a limited statement, and I will tell you honestly, part of me knew it was dangerous. But another part of me knew the courtroom needed to hear who Karen was when she believed she was losing control. She stood behind the defense table, chin raised again, but her voice was sharper now. She said Margaret had been spying on her. She said the whole neighborhood was jealous. She said Harold was lonely and desperate for attention. She said Rachel Morgan had manipulated an elderly woman into suing her. And then she looked directly at me and said, "You people always protect the weak because it makes you feel powerful." The room froze. I had heard enough, but before I could respond, Margaret Collins spoke. Her voice was barely above a whisper. "I never wanted power," she said. "I just wanted to sleep." Those words hit the courtroom harder than Karen's accusation. I looked at Margaret then, and for the first time that day, I saw the full weight of what this case had done to her. This was not only about property damage, it was about fear, it was about humiliation, it was about an elderly woman being made to feel unsafe in the home she had spent nearly 40 years building. Karen opened her mouth to respond, but Rachel Morgan lifted one hand. "Your Honor," she said, "there is more." Karen turned slowly. Rachel's expression had changed now. She was no longer simply presenting evidence. She was preparing to expose a pattern. She asked Harold if he had brought the recording. My eyes moved to Karen. For one brief second, all the color left her face. And that was when I realized the court had not yet heard the most damaging evidence, not even close. When Rachel Morgan said the word recording, the courtroom changed, not loudly, not dramatically. But everyone felt it. Karen Whitfield stopped moving. Her attorney, Thomas Reed, slowly turned his head toward her. Margaret Collins gripped the edge of the plaintiff's table. Even Harold Bennett looked like he wished he were anywhere else in the world. I have learned that some evidence enters a courtroom like a document. Other evidence enters like a storm. This was the second kind. Rachel explained that after Karen had asked Harold to sign the false statement, Harold became uncomfortable. He did not want to get involved, but he also did not want Margaret to stand alone. So the next time Karen came to his porch, he used his phone to record the conversation. Karen immediately objected. "That's illegal," she said, but her voice had lost power. I asked where the recording happened. Harold said on his front porch, in plain conversation, after Karen approached him voluntarily. Rachel added that the state permitted one-party consent recordings under those circumstances. Karen looked at Thomas. Thomas did not look back. That silence from her own attorney told her everything. Rachel asked permission to play the audio. I allowed it. The courtroom speaker crackled once. Then Karen's voice filled the room, not the polished voice she had used in front of me, not the victim voice, the real one. "Harold, I'm telling you, if you help me now, this whole thing disappears." Then Harold's voice, nervous and low. "I can't say Margaret did things she didn't do." Karen laughed. "Oh, come on. She's old. People will believe she's confused." Margaret lowered her head. I watched her shoulders shake once, but she did not cry out, the audio continued. Karen said Margaret needed to learn that old women don't run neighborhoods forever. She said if Harold signed the statement, she would make sure nobody bothered him about his own property issues again. Then came the line that made the room go cold. "If she won't leave quietly, I'll make her look crazy." And then silence. Not from the recording, from the courtroom. There are moments when even a judge must work to keep his face still. That was one of those moments, because now we were no longer dealing with a misunderstanding, a neighbor feud, or two people who could not get along. We were dealing with calculated destruction. Karen had not simply reacted badly. She had planned. She had targeted Margaret's credibility before the case ever reached my bench. She knew exactly what fear would do to an elderly woman living alone. She knew exactly how to twist age into weakness. And she knew exactly how to accuse the court of being rigged the moment the evidence started closing in. Rachel stopped the recording. Karen sat frozen. Then, slowly, she shook her head. "That's not what I meant," she said. I looked at her. Those words always interest me. Not "I didn't say it." Not "that isn't my voice." But that's not what I meant. In law, language matters. In human behavior, timing matters more. Karen denied everything until denial became impossible. Then she changed the defense. That shift told the whole courtroom what it needed to know. Thomas stood, trying to protect what little was left of his client's position. He said the recording was inflammatory. He said neighbors sometimes exaggerate during private arguments. He said Karen's words were inappropriate but did not prove she caused property damage. Technically, he was doing his job. But sometimes a lawyer can only slow the collapse. He cannot stop it. Rachel then placed one final document on the table, a phone record. She showed that several messages sent to Margaret from anonymous accounts were linked to recovery emails connected to Karen Whitfield. Karen's face tightened again. Rachel read one message aloud. "You think court will save you?" Another, "Everyone already knows you're losing your mind." Another, "Move before this gets worse." Margaret pressed a tissue against her mouth. I could feel the spectators reacting behind me, not with noise, but with stillness. People stopped shifting in their seats. Nobody whispered. Nobody looked away. Because everyone understood now, Karen had created a private prison around this woman, not with bars, with fear, with humiliation, with constant doubt. And then she had walked into court and called the system rigged because she believed accusation alone could bury accountability. I asked Karen one question. "Ms. Whitfield, did you send these messages?" She looked at me, then at the screen, then at Margaret. For a moment, I thought she might finally tell the truth. But pride is a dangerous prison, too. "No," she said. She probably sent them to herself. A sound moved through the courtroom, not a gasp this time. Disbelief. Rachel did not react emotionally. She simply asked to call one more witness, a technician from the neighborhood security company. That was when Thomas Reed asked for a recess. I granted 10 minutes, but I watched Karen as she stood. She did not look defeated. She looked furious. And as the bailiff escorted everyone into recess, I saw Karen lean toward Margaret's table and whisper something. Margaret's face went white. The bailiff moved quickly, but Karen had already stepped back. I asked Margaret what Karen said. Margaret hesitated. Then she whispered, she said, "I'll be sorry when I get home." That sentence changed everything, because now the case was no longer only about what Karen had done before court. It was about what she was still willing to do inside it. When Margaret Collins repeated Karen's whisper, I felt the entire courtroom shift beneath the surface. She said, "I'll be sorry when I get home." I have heard threats before. Some are loud, some are foolish, some are born from panic, but this one was different. It was quiet, personal, controlled, and that made it more disturbing. Karen did not shout it because she wanted the courtroom to hear. She whispered it because she wanted Margaret to feel alone again. That was the pattern. That was the weapon. Not just property damage. Not just anonymous messages. Not just lies. Karen's real method was isolation. She wanted Margaret to believe no one could protect her. Not her neighbors. Not the police. Not even the court. I ordered Karen to remain seated and instructed the bailiff to stand near her table. Her attorney looked exhausted now. Thomas Reed had the expression of a man realizing he was no longer defending a misunderstanding. He was defending a person who could not stop herself from proving the plaintiff's case in real time. Rachel Morgan returned from recess with the security technician, a man named Eric Lawson. He was calm, professional, and carried a small folder of service records. Eric testified that Margaret's camera system had been accessed repeatedly before the wires were cut. Not physically accessed, digitally accessed. That caught my attention immediately. Rachel asked him to explain. Eric said the system had recorded several failed login attempts from an unfamiliar device. Then, 2 successful logins occurred late at night. The account password had been changed shortly afterward, locking Margaret out of her own security app. Margaret looked stunned. She had believed the camera simply stopped working. But now we were hearing something far more calculated. Rachel asked whether the company could identify the device. Eric hesitated. Then he said, the login records showed an IP address connected to Karen Whitfield's home internet service. The courtroom erupted. Not into shouting, but into that sharp wave of stunned reaction that judges never forget. A murmur moved from the back row to the front. Someone whispered, "Oh my God." Margaret covered her face. Karen stood halfway up before the bailiff's presence stopped her. "That's impossible." "Karen," said Eric, looked at her. "It is in the system records," he answered. Rachel then asked the question that would become the turning point of the entire case. "Mr. Lawson, did you recover any deleted footage from Mrs. Collins's account?" Karen's attorney closed his eyes. "Just for a second, but I saw it." Eric said yes. The courtroom went silent again. Rachel asked for the recovered footage to be played. And that was the moment Karen Whitfield finally understood that the truth had not merely survived. It had been waiting. The screen flickered. This time, the footage was clearer. It showed Margaret's side yard at night. The image was angled from the porch camera before it was disabled. A figure came into view wearing a hooded jacket, moving quickly but not carefully enough. The person carried garden shears. She bent near the camera wire. Then she looked directly toward the porch light. The face was visible. Karen. There was no confusion now. No shadow, no guess. No could be anyone. It was Karen Whitfield standing outside Margaret Collins's home in the middle of the night, cutting the wire to the security camera. For a few seconds, nobody breathed. Then Margaret began to cry, not loudly, not theatrically, just a broken, exhausted sound from a woman who had been forced to defend her own reality for months. Karen turned toward the screen, then toward me. Her mouth opened, but no words came out. That was the viral moment people would later talk about. The woman who had called the court rigged had been exposed by the system she tried to destroy. But Rachel was not finished. She asked Eric to continue the recovered file. The footage played forward. After cutting the camera wire, Karen moved toward the fence. She struck one of the panels with the metal shears until it cracked. Then she stepped back, took out her phone, and appeared to take a picture. Rachel paused the video. Then she placed another document on the evidence table. A complaint Karen had filed with the Homeowners Association the next morning, claiming Margaret's neglected fence was damaging the appearance of the neighborhood. That detail hit the room like a second explosion. Karen had broken the fence herself, then used the damage to accuse Margaret. I looked at Karen then, and I will tell you something honestly. I have seen cruelty in many forms, but this kind of cruelty carries a special darkness. It is not the cruelty of losing control. It is the cruelty of planning someone else's humiliation, then pretending to be the victim when they finally ask for help. Rachel pressed play again. The footage continued. Karen moved toward the porch. She reached into her pocket, and then the court watched her slide a folded note into Margaret's mailbox. Move before things get worse. The same note, the same threat, the same lie she had denied under oath. Margaret sobbed into her tissue. Harold Bennett stared down at the floor. Thomas Reed sat motionless, his hands folded, knowing there was no argument left that could make this disappear. But Karen did something I did not expect. She laughed, a small, bitter laugh, the kind people use when they are losing and want to pretend they are still above the room. Then she said, "So what?" She made my life miserable first. The room froze. That was not a defense. That was a confession wrapped in resentment. I asked her to repeat herself. She looked at me, eyes sharp, voice shaking with anger now. "You all act like she's some sweet old lady. She watched me. She judged me. She made comments about my yard. She got neighbors against me. I just wanted her gone." There it was, the truth, not legal truth. Human truth. Karen did not believe she had done wrong because in her mind, her discomfort justified Margaret's fear. That is one of the most dangerous beliefs I have seen in a courtroom. The belief that if someone irritates you, you are entitled to destroy them. Rachel turned to me and said, "Your Honor, based on this evidence, we request full damages, sanctions for false statements, and referral for possible criminal investigation." Karen's smile vanished. Now she understood this was no longer only a civil dispute. her words, her threats, her tampering, her harassment, her false accusations, all of it had formed a chain, and every link led back to her. I looked across the courtroom at Margaret, who had endured months of fear, at Harold, who had chosen truth over comfort, at Rachel, who had waited patiently for evidence to speak louder than outrage, and finally at Karen Whitfield, whose first accusation had been that my courtroom was rigged. No, the courtroom was not rigged. It had simply done what courtrooms are supposed to do. It had waited, it had listened, and then it had let the truth destroy the lie. But before I could deliver my ruling, Karen reached into her handbag. The bailiff moved instantly, and what happened next turned a shocking civil case into something far more serious. The bailiff moved faster than anyone in that courtroom expected. Karen's hand had barely reached inside her handbag when he stepped forward and ordered her to stop. For one frozen second, nobody breathed. Margaret's face went pale. Harold Bennett leaned back in his seat. Even Karen's attorney rose halfway from his chair, shocked by what his own client was doing. Karen pulled her hand out slowly. It was not a weapon, it was her phone. But in that moment, the damage was already done. Because when a defendant reaches suddenly into a bag after threatening a witness, after lying under oath, after being exposed on video, the courtroom cannot treat it like nothing. The bailiff took the phone from her hand. Karen shouted, "You can't take that." I looked at her and said, Miss Whitfield, you lost the privilege of being trusted in this courtroom." That sentence silenced her. Not because she respected it, because she knew it was true, The phone was secured. Karen was ordered to sit. And for the first time that day, she looked small, not remorseful, not sorry, just small. There is a difference. I reviewed the evidence again in front of everyone. The damaged fence, the cut camera wires, the threatening note, the anonymous messages, the false statement she tried to pressure Harold into signing, the audio recording, the recovered footage, and finally her own words in court. So what? That phrase stayed with me. Because sometimes evil does not announce itself with rage. Sometimes it appears in two careless words spoken after someone else's suffering has been proven. I awarded Margaret Collins the full cost of repairs. Emotional distress damages were allowed, court costs, and additional sanctions for Karen's false statements and abusive conduct during the proceedings. I also referred the matter to the appropriate authorities for further review of harassment, intimidation, property damage, and witness interference. Karen stared at me as if the ruling itself were an insult. But the truth is, justice often feels unfair to people who confuse consequences with persecution. Then I turned to Margaret. She was crying quietly, but this time her tears were different. Not fear, not humiliation. Relief, I told her. The court believed her. And I watched those words reach her in a way money never could. For months, Karen had tried to make her feel crazy, tried to make her feel alone, tried to turn an entire neighborhood into a weapon against her. But in that courtroom, the lie finally broke. Harold Bennett helped Margaret stand when the hearing ended. Rachel Morgan gathered the evidence with calm hands. Karen was escorted out, still muttering that everyone would regret this. But nobody looked afraid of her anymore, and that may have been the real verdict. I have thought about that case many times since, not because it was the largest case I ever heard, not because it was the most violent, but because it reminded me how dangerous a person can become when they believe their anger gives them permission to rewrite reality. Karen claimed my courtroom was rigged, but the court was not rigged. It was patient. It was careful. It listened when she lied. It waited when she performed. And when the evidence finally spoke, the truth did not whisper. It destroyed her. That is the lesson I want you to remember. A lie can be loud. It can be confident. It can walk into court wearing a red blazer and a smile. But truth has a way of waiting quietly until the exact moment it can no longer be denied. And when that moment comes, even the loudest liar has nowhere left to hide.